Well, good afternoon, everyone. I hope you are all well. I wanted to thank you all for joining us on your Monday afternoon for our Subcontractor and Supplier Lien webinar. I'm Lee Leppert. I'm the Senior Creative Manager here at the Cromeans Law Firm. And today we have Miss Jessica Mora. She's the Cromeans Law Firm's Lien Specialist. And Jessica leads the firm's mechanics, lien, and collection department. She's passionate about her job and helping clients, and enjoys taking on new challenges and thinking outside of the box to problem solve on behalf of her clients. And today we're going to be covering everything that you need to know about how to file a mechanics lien. Subcontractors, suppliers, property owners, and other vendors will encounter all kinds of lien-related questions, deadlines, paperwork, when working on Texas construction jobs. And part of you know about the lien process and how to get paid for what is rightfully yours. And today, Jessica will guide you through the time-sensitive process of filing a mechanics lien. And our goal here, of course, at the firm is to teach everyone how you can best protect yourself on the front end. I sent out a couple emails over the last few days with the handout, so please make sure you're following along if you would like to fill in the blanks with the presentation as Jessica starts. And we will have that Q&A portion at the end of the presentation. So this is your chance to ask her any and all questions that you may have. Just ask that everyone stays muted during the presentation. And any questions that you may have regarding any liens questions, you can send to me via chat. You can also unmute yourself when we start that Q&A portion. I guess without any further ado, Jessica, go ahead and take it away.
Good afternoon, everyone. So let's go into why liens are so important. The entire construction industry revolves around credit. This is the reason why liens, mechanics, and material liens are important. It is to secure your credit, to secure your money when you're working on a job. Sorry, guys, my throat's a little fried today. Liens are a way to secure credit on a construction project. Liens are filed in the real property records. They are against the property owner's actual property. Even when the owner does not hire you directly, you still have lien rights. Because the owner may never know who you are or never had a contract with the claimant, the laws require specific steps to have a valid lien. By following the specific steps, the owners will have to pay you even if they don't agree to it. If the claimant misses even one step or one sentence that is required in any of the notices or the lien itself can become invalid. So it's very important to know these steps. I'm sure everybody in the construction industry knows how the construction tiers work, but if not, let's just go over them a little bit. The owner usually has a contract with a prime contractor. So the contract is usually between the owner and the prime contractor and or a GC. So usually that owner will never know who are the tiers beneath them, a subcontractor or a supplier. The GC has a contract with subs, therefore the supplier may not know who that GC is. The subcontractor has the agreement with the GC, so they don't really know who the owners are. The supplier, their agreement is usually with a sub, so they don't usually know who this GC is or the owners are. So pretty much nobody knows who each other are on these jobs unless you're either asking, doing some research to figure out who all is involved in a job, which is very, very important at the end of the day. Who can file liens? Anyone who supplies labor or materials for a construction or repairing a house, building, or improvements to a property are entitled to liens. If you look at this slide, it has 4 different types of liens. You're going to have a homestead, a residential, a commercial, and a public works. We're going to go into a little bit about each type of job. So we're going to start off with the homesteads. Okay, so a homestead, yes, it is a residential job. The problem is it's a homestead because that's the type of property that is. And when I say homesteads, the state of Texas protects your homesteads. They protect our homes. So for anyone to be able to have a lien on a homesteaded property means they've got to file their contract of record. This protection means not just anybody can go file liens on your houses. The contract does have to be signed, notarized by all owners. If it's husband and wife or married couple, both must sign your contract. That contract is then taken and filed in the real property records where that property is located. Example, if an individual does not currently have a homestead and is building a residence, which they intend to be their homestead, that is considered their homestead. And a supplier or a sub will not have lien rights unless there is a contract filed of record with that prime contract and the owner. Who have rights to a homestead? A little bit about this information. The GC or the prime contractor has a direct contract with the owner. Because they have that direct contract, they have what's called a constitutional lien. However, for them to have a lien, a physical lien on this property, they must file their contract of record. For the subcontractor to have lien rights, the only way they can file a lien is if that general contractor filed their contract of record. If they do not file it of record, they do not have lien rights on a homestead. Suppliers, same thing. If there is no contract filed of record, you will not have lien rights on that property. Notices and statutory guidelines on this is the sub and the supplier must follow the statutory timelines with notices and filing your liens to have a valid lien on a homestead property. So residential does mean properties. Residential properties, if they're owned by they can be owned by an individual in their own capacity, but it's a different property than their homestead. You're only allowed one homestead in the state of Texas. So if I am building another house and I currently live in my homestead, I can't say that that one's my homestead, okay? Vacation homes, rental homes, anything that falls under an entity, if it's a company that's owning it, an investor, those are not considered homestead, but they are under the residential timelines, okay? An individual has his or her spouse again, they're only entitled to one homestead. Here's another, sorry, I'm all over the place. If you are building a residence while living in your homestead, the new one cannot be considered your homestead. Vacation homes, beach houses, those are not considered homesteads unless it's your prime residence. What are your rights on a residential job? Because it's not your homestead, there does not have to be a contract filed of record, okay? Let's see, you can file a lien at any time. Oh, sorry. The GC can file a lien at any time as long as the person that contracted them continues to own the property. So if I did work on a vacation house and it's been going on for over a year and I still have not been paid, as long as a year later they still own that property, I can go ahead and file a lien without sending any types of notices if I'm the prime contractor or the general contractor. Subcontractors and suppliers, you will have to follow the statutory guidelines, timelines to file a lien, meaning you do have to send your notices on time and you have to file your lien on time to have a valid lien on that type of residential job. So this is a timeline of residential projects. They are shorter. Please note that they do go off of when you did the work, not when you do your invoice. For example, January, if I did the work in January and I have not been paid, my first notice to the general contractor and the owner must go out by March 15th. My lien has to be filed by April 15th. The next slide will have kind of more in-depth examples. The first statutory notice is an intent to lien notice that goes to the general contractor, owner, and a customer. This is kind of for like a material supplier. If you're sending out your first notice, I would definitely include your customer in these notices so they can see that you're sending out your notices on time. They must be sent by the 15th of the month. Certified mail return receipts are required. Remember, you must include your invoices or your accounting statements. It does not matter if you supply at the beginning of the month or the end of the month. They all fall under the same timelines. If you miss the intent notice or send it to the wrong address for any reason, do not file your lien. It will be invalid. There is a $10,000 penalty for filing an invalid lien. Lien filing, file the lien by the 15th of April, and the real property records where the property is located. When I say real property records, I mean if the property is located in Harris County, your lien has to be recorded in the Harris County real property records. Your lien should include the owner, the general contractor, your customer information, who your agreement was with, a legal description, when and what type of work did you do, and the date the notices were sent. So the date notice sent would be the initial notice you sent for the intent to lien. That date has to go on your lien. A copy of the lien must be sent to the owner, GC, and the customer within 5 days of filing your lien. You can send a copy of the lien being filed. You do not have to wait for the original to come back to you. What that means is if I'm filing a lien today, I have 5 days from that date that my lien was filed to send a copy of it with my notice to all of the parties. Now, I have seen where some people wait, oh, well, I didn't get the recorded copy back. Please don't wait for it because you will not get it back within 5 days. Go ahead and send them just a copy, certified mail, and you will be in time for your lien. So job site, commercial, we're going into commercial, spec houses, warehouses, shopping centers, private schools, etc. Those are all considered commercial jobs. Even spec houses that are considered commercial jobs, I personally like to tell our clients to keep those on a residential timeline just because they flip so fast. They're building houses so fast now that by the time you start sending notices, they've already sold. Most commercial construction projects have the following tiers: the owner, the general contractor, a subcontractor, and suppliers. Again, remember that they don't know who each other are unless you've asked or done some research. Sorry, my screen just went out. What are your rights on commercial jobs? Commercial jobs, they do not require a contract filed of record. However, some of them do have bonds. If it is not a public works job and they have a bond filed, you do send your notices to the required parties. Sorry, I thought I turned my volume off. Those will be recorded. Sometimes they're not. You do still have lien rights on them, but you still send notice to the insurance company as well if there's a bond on a commercial job. GC or prime contractor does not need to send notices. They will have what's called a constitutional lien. As long as the person you contracted with continues to own the property, you can file your lien at any time. A subcontractor, because you do not have an agreement with the owner and the owner does not know who they are, they must follow the statutory timelines and send notices with their information and the information of monies owed to them. Suppliers, equipment rental companies, because the general contractor does not know who you are, they don't have an agreement with you. You also will have to send notices based on the statutory timelines. That notice has to include the information and the debt that's owed to you as well. The timelines for commercial jobs, if you notice, there's 3 lines here, which means you have the first notice that will just go to the general contractor. That second notice does include the owners. And the third one will be filing of your lien. So this is a little bit of an example on if you supplied labor or material in January, your first notice goes to that general contractor by the 15th of March. Certified mail return receipt. Remember, you must include your invoices or accounting statements. It does not matter again when you supplied equipment, when you supplied material or did the work, they all fall under the same timeline. So if I did work the 28th, 29th of January, it still falls under March 15th. That second notice is the intent to lien notice that goes to the owners, the general contractors. That notice has to be mailed out by April 15th, certified mail. Remember, you must include your invoices or an accounting statement. Again, if you miss the intent notice or you miss that general contractor notice, you do not have lien rights. Your lien rights are now gone. If you file an invalid lien, again, it is a $10,000 penalty. Your lien for monies owed in January, your lien must be filed by May 15th. Again, you must include the owner's name, the general contractor, who your agreement was with, a legal description, when and what type of work you did, and date of the notices that you sent out. So both notices, dates do go on this lien as well. A copy of that lien should be sent to the owner and the general contractor within 5 days of filing that lien. Public works. So public works is very different. If you look at the examples on there, it'll tell you it's fire station, police station, schools, anything owned by the county or the city is considered public works. Because the city or the county owns public works, they're exempt from filing a lien. We can't file a lien on those. However, they do have what's called a payment and performance bonds. The GC is required to have a payment and performance bond on public works. You will have to, so what that is you have to file a claim on that insurance company if you're owed money for any public works jobs. What are your rights on public works? Subcontractors, suppliers, to have a valid claim, you are required to have a copy of the payment and performance bond from the GC owner and follow the notice requirements. If you do not ask for this in the front end, you will be scrambling to get it because they do not let. I have issues with general contractors or even public works having to get me that payment bond. So recommendation from us is to try to get it in the front end. Your first notice to the general contractor, what I like to do is including in my notice that I'm owed money, you should always request a copy of that bond. Why? Because you still have another 30 days before you have to send out that second notice filing your claim. So your first notice, you must include the amount you're owed with your invoices, and you should also request a copy of that payment bond. Your second notice, this notice is mailed to all the parties. At this point, you make your claim to the payment and performance bond to the insurance company. This must include an affidavit, a sworn statement, along with your invoices, payouts, or statement of account. Sworn statements and affidavits are a must to be able to perfect your claim on a payment bond. Timelines for public works are kind of similar to the residential ones. They are smaller. So your first notice will go only to the general contractor. At that point, you should request a copy of the bond if you do not have it. The second notice is the one that goes to the surety, the owners, and the general contractor. So any work done in January that you have not been paid for, your notice goes out March 15th to that general contractor. The second notice is your bond claim, owner, insurance company, and GC. They all must be sent out certified mail return receipt. Please remember that this notice does have to include an affidavit of sworn statement along with a copy of the bond. If you do not have that bond, but you have the information What we usually do is we'll include it in our notice, in our claim, but it's always better to have the actual copy of the bond. Just a little bit of research tips that I like to give out is a lot of people don't have job information sheets, which I kind of like our clients to have because it gives us all the information for each job. It's very simple information, pretty much the job name, the exact address. If you have the GC's information and address on there, great, put it on there. Also, if you have the owner's information, put it on your your job info sheet. It's always good information to have if you ever have to do any of the collection portion of it. Verifying information provided. Not sure how many of you are familiar with the CADs. Harris County, HCAD, Fort Bend County has an appraisal district. They all have them. It's very simple to use. You can go in and do some quick research as the address that you're going to be working at, and it will come up and tell you who owns the property and what type of property it is. So can you go to the next slide, please? Okay, so this is kind of what will be coming up on a CAD when you put in that address. It's going to tell you if it's a residential. It says real property, residential, single home. It'll also tell you if it's commercial. If you look at that one, it says real commercial. Public works, it's going to say exempt. If it says exempt, that means it's a public works job. So that's a great tool to use when you're looking up the addresses and trying to figure out, is this a commercial or is it a residential or what type of job this is? Use the CADs. They usually tell you what type of project you're going with. The next one is the Texas Comptroller. Texas Comptroller, if you have an idea of who the GC is, but don't have their mailing address, you can always look up an entity on the Texas Comptroller. Put in that name there and it will give you their address. Another one that I like to use is the Secretary of State. For this one, you will have to set up an account, but this one actually tells you if a company, you can look up an LLC, you can look up incorporated, like Incs. What's also good about this, you can also look up a DBA. So if you don't have, they're not incorporated, or they're going through another name, you can look up the DBA that ties to that LLC and get their address as well on there, which is always important to have the correct addresses. If that address is off by 1 0 or 1 number and they did not get proper notice, your lien can be invalid at that point. All right, we're going to go into the breakdown of retainage, which is nobody's favorite subject or part of this. By enforcing retainage, you can learn to protect yourself, your money, time, and resources in your construction project. A retainage allows the client to pay only a portion of the full amount of the project and withholds the rest until the project is complete. Going into retainage, defining it, retainage is a standard practice within the construction industry, and it's required by nearly all construction loans. It is 10% of the contract amount between the owner and the original contractor, general contractor, prime contractor, however you want to call them, on the project. Although legal definition of retainage says nothing about subcontractors, most original contractors take 10% from the amount due to the subcontractor throughout the project. So what that means is, unless it's really in your contract, the contract usually reads that it's the owner and the GC, but that GC will usually take 10% off out of your check throughout the job from a subcontractor. Every contractor an owner hires directly is called the original contractor, prime contractor, or GC. If any owner hires any of the trades directly, each contract is an original contract. This is important because all lien claimants could be limited to only 10% of the contract where they supply labor or material. Why is retainage important? First, if adequately withheld, retainage is essential because it can be limited. It can limit the owner's liability. For example, if the owner withholds 10% of the entire project amount from the original contractor until 30 days after final completion, the owner's only liable to lien claimants will be the 10%. If the amount of the lien claimants exceed the retainage amount, the valid lien claimants will share that 10% pro rata base. Let me explain that a little bit more. If their contract is for $100,000 and that owner withheld it properly from the GC, and we have 6 different lien claimants that filed liens, they're all going to only be able to share that 10%, even though their liens are for more than that. So how we figure that out is we don't have to share that 10% if a lien is bad. So what we've done in the past is we'll eliminate liens. We're like, hey, your lien's not good for this and this reason. We shouldn't have to share that 10% with you. Okay. Second, if the owner properly withholds the 10%, the time frame of filing liens could be shortened. If the project is completed, an affidavit of final completion is filed with the county clerk and the owner withholds the 10%. So remember that all liens must be filed within 30 days of final completion. Normally, a lien claimant has until the 15th day of the 4th calendar month after material is applied to file a lien. This time frame can be shortened by 30 days after final completion if the owner follows the steps above. That part is always the tricky part, guys, because if you come in at the end of the job, and when it says 10%, like final completion means everybody's done. The entire scope is done. The entire job is complete. They're about to take possession of the property. That's final completion. If I come in the front end and it's a year later till the job is complete and they file that affidavit of final completion, that is when my retainage is due. So I have got to file my lien within 30 days. So if you come in at the end of the job and your timeline has literally been shortened to 30 days. So you're no longer on the timeline of saying, okay, I have 45 days to send out my first notice, then the next notice, and then I file my lien. No, you are literally all narrowed down to 30 days. Retainage generally does not become due to the subcontractors until 30 days after final completion and or when the general contractor receives the retainage payment. This ensures that the subcontractor will have a valid lien on retainage. They should file their liens at the time completion of the project. It reads kind of different to me. So what we usually tell our clients is if retainage isn't due till the end, if I'm done within the first 6 months of the job, you should go ahead and file your lien for retainage. Why? Because are you going to remember to file that lien a year later? Probably not. So that is important to make sure you send your notice for that and go ahead and file it as soon as you're done, because even though it's not due to them, it's already still been on your invoices. So it's important to get that notices out and get that lien filed to protect your retainage. We're going to go into a little bit about waivers. So the state of Texas has provided 4 statutory waivers that should be used. Those are conditional on progress, unconditional on progress, conditional on final payment, and an unconditional on final payment. The conditional on progress is pretty much saying, I'm giving you this conditional waiver. You're going to be sending me a check, and it's paying me for work done through A, B, and C. So for example, if I did work in January, February, and March, and I'm getting a payment for work done in January, you should include in there that you're getting paid for work done in January. This is usually required before getting your check. Unconditional non-progress, meaning that check is cleared. So I got paid for January. I signed a conditional. That check has now cleared my bank, so I no longer have lien rights on that money. I will give you a unconditional on progress payment, meaning I'm still owed money for other work performed. Conditional on final means I am receiving my final payments and I'm giving you this because you're about to pay me for it. I will wait for that check to clear to give you my unconditional, meaning I'm done, there's nothing else. Unconditional on final means my check has cleared my account, you no longer owe me any money. When signing this, please make sure you have no balance due. This even includes retainage. So if you're saying I am completely paid in full, means you have nothing owed to you, you have no more lien rights, you are completely done. Please be careful with signing an unconditional on final payment. So those are all of my slides, and I am very interested to find out if you guys have any questions.
Thank you, Jessica.
Welcome.
Right. Yes. So we are now in the Q&A portion of our presentation. So please feel free to send any and all questions via chat. I can read them aloud to Jessica, or you can also unmute yourself and ask her directly. We have any questions for Jessica? I have one for you, Jess. We get this asked often. Can you amend your lien?
No. Once your lien is filed, you cannot amend your lien.
Okay. What happens if you don't send the notice to the right person?
If you do not send your notice to the right person, your lien is invalid.
What would the next steps be? So let's say that someone here call you directly and you handle the rest.
So when you don't file a valid lien or you don't send notice timely, you're kind of out of your lien rights. So the next step for you would be to have a breach of contract claim, which is a lawsuit against the person that hired you directly. You can't go sue the owner or anybody else because they didn't hire you. So, and it's harder to get your money that way. The lien is made specifically to say, okay, I did work on this job, so I have an interest in that property. So that protects your money. Why? Because it's actually something that you can collect from versus just suing somebody and getting a piece of paper that says, oh, here, you've won this amount of money, but are you physically going to be able to collect from that?
Mm-hmm.
And how I explain it to a lot of our clients is, I think I had one a few days ago. It's an apartment complex that he did services for, and he did work. He's owed about $100,000 on it. And he's like, I need to file my lien. I was like, yeah, you do. They're not going to risk losing this $1 million property for $100,000. Do you see what I mean? Because your lien is good, you can file suit to foreclose on your lien. What they don't understand also is that liens do expire. Liens, a residential lien expires at a year. A commercial lien expires at 2 years. So there's always the next step in perfecting that lien. But the best thing is to make sure there's something that you know you're going to be able to collect from, and that's by filing a lien instead of just getting a piece of paper because you sued somebody.
Mm-hmm. Very good to know. Do you have any other crazy stories?
Oh, I can go on and on about my crazy.
You could write a novel.
Yeah. Any other questions? Don't be shy, guys. I know somebody has a question. It's okay.
Well, we have this webinar recorded, so I will be posting on our social media. I'll be sending out a follow-up email. It'll have Jess's contact information, so if you do have any questions for her, you can feel free to call or email her to set up a phone call with her. She is here at your disposal to ask any and all questions. If you don't want to do it right in this moment, you can set up that consultation with her. And I'll also be handing out the presentation in that follow-up email I send out. So you'll have that full presentation, and then the recording will be sent out tomorrow on our social platforms. If you have any other questions, we might be closing out early today, but we so thank you for attending our subcontractor and supplier webinar, and I hope you have a great rest of your week, and we'll see you really soon. Thank you all.
Bye-bye.